Welcome to CAM Radio, an Ahead of the Curve initiative by Cyril Amarchand Mangaldas, bringing you every Friday the latest in legal and policy. Stay tuned. Enjoy listening.
It's such a privilege to have such an erudite and experienced panel. We will be discussing technology, which raises some really profound as well as immediate questions of us. Of course, it has transformative power as well as fatal risks. And it raises questions, as I said, profound ones like, is justice a physical location or a service or a process? Does the right to justice include the right to human reasoning and a human decision? Can AI give a judgment like Juliana? I don't know. Perhaps not. Can it go into questions of science of standing and so forth? Can AI be held accountable? Can ChatGPT be impeached? But also sort of more immediate ones, like how can technology be deployed for better case management, resourcing, predicting caseloads, making the judiciary more effective? Maybe a technology-driven judiciary is better than, a slow, creaky one that doesn't deploy technology at all. So we're going to tease out those questions with this absolutely stellar group. We'll start with Padmaja, who is the General Counsel of the Citi Group. A lot of international experience, and I recently found out has written folk stories. Let's start by just asking you, as a user of courts, both in the US and India and internationally, what kind of changes would you like to see?
I see we've started with a nice, tough question, Richa. Thanks for that, and thanks for picking me first to answer that. I will definitely answer that without beating around the bush. But before that, just wanted to say thank you to Cyril and Raj for inviting me. I have to say on a personal note that sitting here in the audience today are icons of my childhood, my formative years, growing up. It's an absolute fantastic privilege to be here. As Justice Lalit himself so humbly said, that for him this is a huge opportunity. So if he's saying it's a huge opportunity for him, I think it's a pretty big one for me as well. So and to share this panel with everyone that's on stage, it's a very special moment. Talking about technology and the changes that we would like to see. When Cyril, Richa, and I were talking about this session, just as a little bit of preparation, Cyril said to me, "Why don't you talk about your experiences representing Citigroup, because Citigroup is in the US and in India, and you have vast operations in both countries." And so that lends an interesting perspective to how you use courts and what are the changes you would like to see. So the one thing that I can absolutely say is, and just sort of taking something from what Justice Kumar had said earlier, that while our countries are quite different, our hearts are alike. And I feel that, like a user of courts in the US and in India, frankly, our goals are alike as well in terms of what the judiciary and consumers of the justice system are trying to get. I think the journey in terms of the use of technology is a little different. One predates the other, but in terms of what it tries to do is similar, which is create transparency, create fairness, create access, and create a timeliness in the delivery of justice. I think that is what the power of technology really is trying to do. I think where the differences come really is in the prioritization. Because when you look at budgets, when you look at resources, they are finite. And therefore, how you prioritize them depends on what the country's goals and needs are at that point of time. Very interestingly, and I'm sharing the room with judges of the federal system in the US, and I was reading something called a long-term fiscal report of 2023 of the federal judiciary. And it was so interesting because it was talking about the strategic priorities. And a lot of it comes down to easing the administrative burden, filing, access to information, record keeping, or even the general public's use of the court system, like the PACER system. It's fantastic. And I think the pandemic has shown how the evolution of that can step up and ramp up so very quickly. One of the big, I think, focus areas in the US, even as Citi using the court system, is just the security of information. And I know there is a large budgetary ask for, amping up cybersecurity, in addition to sort of easing the administrative burden. When it comes to prioritization in India, I think where it comes from is really when you look at the inflection point the nation and the economy is at today. So we all set to be $1 trillion economy. That's happening because enterprise, commercial enterprise and economic growth is reaching a diversity of geography that previously was untapped. So it's a diversity of geography and a deepening, a penetration in very rural areas. Now, if you think about what that inflection point looks like, it's driven by technology. So the use of access to the internet, use of mobile phones, access to payment infrastructure. Today, you can have a tea stall vendor in a fairly remote area on a highway in India, and you could just, with the use of 2 phones, provide payment. And I think if we had this conversation 5 or 10 years ago, I don't think it would have been as timely as it is today because of the kind of digital penetration that we've got in India. So when you think about the country's prioritization, to get to $1 trillion, we are going to have to make sure that commercial enterprise reaches across. And if commercial enterprise reaches across and deep, that means access to dispute resolution also has to commensurately expand. That can only happen effectively with the use of technology. And so if we were to identify 2 priorities, I would say the change I would like to see is not actually in terms of new ideas or more ideas. I think what we need is nailing which amongst the many great ideas that we have. So the E-Courts Committee from 2021, which you've spoken widely about, has identified 3 phases of priorities. And so the goals are immense, the challenge is immense. So if we say that what are we picking as the 2 main ones to support the idea of building the nation, one would be access to people without necessarily having to go through as many legal practitioners, without having to travel miles and miles to get to a court, through the power of their mobile phones and through the power of the internet. So whether it is knowing how to file something, whether it is being able to file an application, a very simple form of application. We won't get into AI just yet. But it is really that, using technology to create access. And the second priority I would say that we should really focus on is, and I know some of the panelists in the previous session talked about this, using technology to create alternative dispute resolution for commercial parties. Because they can quite effectively do their own dispute resolution using a technological platform. And I know some of our regulators, like the SEBI, for example, has made significant strides. So I'll pause there, Richa.
Thank you. That was really valuable, and I think you bring such a unique perspective in terms of the financial penetration along with digital penetration and how that's going to impact access to justice. That was very, very valuable. I'm going to go to Judge Staton now. Judge Staton, you serve at the United States District Court of the Central District of California. You've worked in private practice and in the judiciary in the past. And that's why I think you're uniquely placed to answer this question. Professor Richard Susskind at the University of Oxford says that the court is not just a physical location. It is providing a service, and it's a service of sort of dispensing justice. I'd love to hear your views on that, as well as how you think technology can change the provision of justice to previously untapped population.
Thank you for the question. And I have to start by saying that some of you in the audience know that over the course of the last 2 days here, I have not been able to figure out how to get onto our WhatsApp group community chat. And so, same here. And so, those few of you might be wondering why I am speaking or qualified to speak on this topic. I want to assure you that that is a glitch, that I do understand at least the basics of technology. And the way the question was posed, or at least has been posed by Susskind, is the court a service or a place. And I think the way you framed it is much better, because it is not a binary question, is it? It is not a decision. Is it one or the other? At least in the foreseeable future, it is going to have to be both. And maybe there will be some time when AI takes over and we need no physical locations and technology has us in wherever we want to be in a virtual environment. But we're not there yet, and I'm not going to try to predict 10 years out. And so what I'm treating that question as, is it a service or a place, as a catalyst for discussion. And while I can, and I will talk for the next few minutes about this, I think of all the topics that we have here, this is one that really is best served by debate, by brainstorming processes, because I think that we're really going to have to answer that question over the course of time. And so the real question is, what is going to be the balance between place and service? I'm going to give you a little bit more of my background, just because I didn't do that earlier, and I know you mentioned it, but it informs my perspective on this. Before I was a judge, I was a litigator. I was a trial lawyer at Morrison & Foerster, which is a very large U.S. firm, international firm. You may know of it. It's not Sullivan and Cromwell or whatever. But it's a large law firm. And pardon?
Lots of tech.
Yes, lots of tech. It's a San Francisco-based firm, and that's what it does. And litigated a lot of cases and tried cases, and so I'm very familiar in that sense with what lawyers want in the courtroom, both pre-trial and trial-wise. I mean, when you're a trial lawyer, it's not just pre-trial. You want that place. There's an art and a beauty and an element, an elegance to the courtroom that doesn't exist on the screen. And so I'll fast forward in a moment. But then when I was a state court judge for 8 years, I handled what state court judges handle at the trial level, which is every little matter, including misdemeanor cases in criminal law, including family matters, where people oftentimes represented themselves. They couldn't afford lawyers, and also some larger civil matters. Then about 13 years ago, I went on the federal bench, and we handle very complex matters there, but we also have pro se litigants as well. So we have everything from the small case, and I've handled everything from the small case to also what I'm sure my colleagues have handled. I know Judge Barat has, and that is an MDL, which is multi-district litigation. Those are the big dollar cases. You may be familiar with that process in the United States. We have a multi-district panel that will have hearings on how to consolidate cases in one court. So you'll have a nationwide group of class actions, multiple lawyers across the country, all consolidated in front of you as an MDL judge. And so I've handled those kinds of cases as well. So it cannot be a one-size-fits-all response, because is family law important? Absolutely. Can those litigants afford to litigate to the nth degree? No, they cannot. But the multinational corporation, while you may have some difficulties and preferences, you can afford to do that. And sometimes you want to have all the bells and whistles. You want to have the opportunity for remote location. You want and remotely appearing. You want to have the opportunity to be in the court when you need to, and have all the facilities available to you. And so what I think the next step is for the federal judiciary, and we're much more of a Titanic large ship kind of thing, so we just don't turn easily, right? It takes a long time for us, and we're probably going to hit the iceberg. But I will say, because we're always a little late, but I will say what we need to do is we need to have a more uniform response. And this goes to the idea that was raised earlier by general counsel that you want some predictability. You want to know what procedures are available to you. And right now it is sort of the Wild West in the federal courts because every judge is his or her own king in his or her own kingdom. And we create our own processes. I have a procedures page on the website for my court, and I essentially dictate how you're going to appear in front of me, whether you can appear remotely, when you can appear remotely, and it may have little resemblance to what the judge upstairs or down the hall tells you you have to do. And what's the predictability in that? And so I do it to fill the void. Otherwise, you'd know nothing. But it's not an ideal circumstance. So what I think that the legal community can do best to assist the court is to come up with ideas, through your organizations, come up with ideas and strategies and procedures that you would like, that you can agree upon, and then present them to us. So thank you.
Thank you. We'll absolutely take that on board. And, to the physical location point, I believe you're headed to the Bombay High Court next, which is a beautiful building architecturally. So I think, we want to continue, as you said, to keep the physical location as well as the service, which can be dispensed in any manner. Judge Aiken, I'm going to come to you next. I know you said you were also struggling to get on to the WhatsApp group. So, but I have no doubt that, you're well placed to talk about technology. But I'm just going to ask you what you think the justice system is going to look like 10 years from now, how it's going to change by the forces of technology as well as some of the forces that the judiciary is responding to, and what we should preserve from the current system.
An incredible question. And I'm looking at it, people are going to know much more about that answer sitting in the back rows and listening today, but when we should be listening to you, to be honest. You don't know a lot about my background. I came in sort of late, and I've come in late again because I have the privilege in the ladies' room, which is where really good things get done, just as in the men's room where you actually meet people, to meet with an incredible woman who's here listening in. So it's really about individuals, and so we need to take more time, Raj, on those breaks to have that opportunity to meet people. Just a thought. Here's what I want to tell you. I'm the mother of five. I was mother of 5 boys. I was married to a constitutional law professor, constitutional political science professor who taught constitutional law, civil rights, civil liberties, wanted to give values to his students before they all went to law school and became operators for the corporate world. Sorry, he was just that kind of guy. He actually, the word he used was pimp. But I would tell you this, what he really wanted was to give values so that they remembered when they became wealthy, famous, and important, that they went to school for values. And he taught them those values, whether it's equal rights, whether it's voting rights, whether it's poverty, whether it's doing community projects, whether all those issues. He ran a Supreme Court simulation, and so they had to predict where courts were going to go and what they were going to do and have to think ahead. He was a critical thinker, and he provoked everyone, and was one of those professors that probably in today's world would be considered to be harsh and demanding because he expected excellence. So I was trained in that vernacular of it's about where are we going to go and what is the law going to do for others, not what it's going to do for us. So fast forward, I ended up going to law school, ended up clerking for a court, hired 8.5 months pregnant, walking down the street, no jobs, woman, husband, my husband was at the University of Oregon, there were no jobs. And I got hired by someone who ran a litigation practice, thought I'd do litigation in I science kind of gal. And I got handed every case with a woman lawyer on the other side. They were all family law cases. I'm on the federal bench. Let me think about it. But fast forward, because I juggle. It's not juggling. It's about doing lots more work, more efficiently, using resources, and being an organized person. You don't put 5 kids to school every day and meet your obligations at home and carry a practice without knowing how to juggle and how to organize. That's a skill we don't teach in law school. Organizational ability, how to move things forward, how to get it done. Exactly what Sarah had to say, and that is managing our dockets. Most judges, let's just let the lawyers do it. Nope, we have to manage the stuff and move it, and our expectation should be how much we're getting done and how we organize it and how lawyers push us to do better work. So I want to step back. My real training in all of this is by boys video games. Video games have really changed how everything's done. These kids can do anything and everything. And my fourth son bought his own computer when he was 12. And I couldn't believe, I thought, what is this all about? And he was a vidiot. That's what I called him, vidiot. They had friends over all the time. These guys lived on their video things. So why is that important? Well, it ends up, he goes on to medical school. He used to be a phenomenal surgeon. He blew everybody away with laparoscopic surgeries. He had these incredible skills. He had an ability to unravel things that I can't even begin to tell you. And what having those boys taught me was, I had to stay current. So what I'm going to tell all of you is what the joy of my life is to be a reciprocal mentor. I learn more from the students. I've had 225 law students work full-time in my chambers. I learn more from you that moves me ahead to do the work that I do because you push us to do it better. Nicole Arbach, one of my heroes, who does a fabulous talk. I've had her speak a number of times. TikTok, ban the billable hour. It rewards failure and people who can't get it done. And it's really all about juggling and how much you can get done and how you prioritize and how you move people to get things done. So I think that's a skill that we don't teach people. And what we end up doing is everybody's in their swim lane going one thing at a time. And I couldn't manage my docket that way. My docket is a myriad of every kind of issue, topic, complicated class action, from the most complicated environmental case to the simplest case. But I want to go back to basics. In the United States, the horrifying fact is only 20% of our population can afford a lawyer. 80% of the population can't get a lawyer. And we have a constitutional obligation to provide a lawyer for a misdemeanor, which is a 1-year jail sentence. And that's going to really do damage to somebody's life. But you know what you do? You ruin a child when you can't get them a family lawyer and you can't get them stability in their life and you start filling prisons. So I'm about practical applications of using the power of technology to make a difference. And so I built a relationship, and I have to talk about a couple of people. And I also believe COVID taught us an enormous amount of information about how we can do this. And it's a question of embracing it or returning to the bad normal that wasn't working. Courts are a process, not necessarily a building. It's about getting the work done. And so I'm in Oregon. I went on the federal bench 25 years ago. I was a state court judge for 10 years, and I was a practicing lawyer for 10 years. And I raised my kids through that period of time, and it took juggling. And it took using the best technology as fast as it came out and putting it to use. But I'm going to tell you, honestly, it was the reciprocal mentorship of undergraduates using technology that pushed me. Two of those people, you should write it down and you should find them. Daniel Katz, who's at the Chicago Kent Law School, one of the leading experts in the country, PhD from Michigan, data analytics, one of the first people to start tracking all this stuff and doing predictive analytics. He is a wizard. And I haven't had a chance because we don't have enough time to talk to Raj because we're on this, open schedule. To tell him you really need to bring him over here he's unbelievable. And he has done a remarkable work. And he put together with a $500,000 grant, something called Reinvent Law Silicon Valley. And this is like 15 years ago. And we went down to Silicon Valley and he called me and he said, will you bring people from Oregon? And I said, oh my God, I'll go to anything. You're amazing. And he said, no, I want you to speak. I said, what? Speak? I can barely use this. Are you kidding me? I'm not speaking down there. And he goes, no. There'll be more money in the room and people in the room, and you got problems. You bring them a problem. So I brought them a problem. And they had 44 presentations in one day, the top minds in the country at the Computer Science Museum on Palo Alto. And you looked around the room, you could not believe it. 44, so you needed about 6 or 12 minutes to present. It was the most incredible conference I've ever attended. And I had people coming and begging to help me with my problem. And so I started this incredible relationship. This is 15 years ago with some of the leading people in technology. And fast forward, he did it again in Cooper Hall in New York. and it was jam. It was like a rock concert. It was hilarious for nerds, legal nerds. But it was unbelievable. And the scholars came because there was no ability to talk to judges. And we got people to come and we started having a dialogue. And then I've stayed as closely in touch with Dan as I possibly can. And a gentleman by the name of Michael Callier, who's at Factor. And he's another unbelievable from the, investing in somebody who had nothing going for him. He was a football player who's fantastic. He has a great career, but he suddenly just got this incredible connection to technology and ended up working in China, learning to speak Chinese and working in the industry in China and then coming back, bringing it to the United States. I mean, he's off the charts. And so what I want to tell you, where do I think it's going to be in 10 years? I don't know. And I can't guess that because you know what? Those kids are 10 and 12. Where we're going to go, you guys have to drive us. And the arrogance of the judiciary, is we think we've learned it all. And it is about intellectual curiosity and caring enough to pick up and work with our students and to bring more students into our chambers and have them teach us. I cannot begin to tell you the advantage. Like I sat here and made a million notes. The next thing I want to tell you is what I took to the problem I took to Silicon Valley was I said, here's the deal. I run a program for people coming out of prison, reentry court. Because, we bring people out of prison, they've been away from technology. They didn't even know what a cell phone was. A street light that tells you to cross the street and start talking to you, they were running the other way. They were so afraid of how the world worked. Grocery shopping was overwhelming. And so what we decided to do is, holistically bring all these services together and help bring people back in thoughtfully. They paid their debt. They deserve to come back and be treated as human beings in our system. And what we found was in using, again, science, risk, need, responsivity, how to address their particular needs from a criminal justice standpoint, it wasn't good enough by far. We needed acute responsivity because these guys can't stop in the moment and say, oh, I'll take that problem next Tuesday and we'll just get the answer next Tuesday. They're in a crisis. And so what we ended up doing, simplistically, is we handed out our phone numbers. Now, mine was one removed, but I'm 24/7, 7-Eleven, I'm available. If you need a problem, we're going to get it done. Because again, it's trying to change how people respond. Risk, need, responsivity. And so what we decided was, the problem I took down there is I said, I need an app. I need something that is a quick fix. And so we did this PowerPoint and we made a cell phone and we put in all the things we would want, all the resources, behavioral changes, all the neurosciences, all the things to use incentives, not punish, incentivize people to do better work. Just this incredible array of resources and how to connect. And we put that together in a video. And guess what? I had MIT volunteer, I had Stanford people volunteer, I had projects money coming to say, what can we do to figure it out? And as it turns out, we found the right person who understood exactly the behavioral concepts we were working on. And he had already designed something that dealt with use of alcohol. We have big issues in our country with drugs and alcohol, huge issues.
Opioid crisis.
Huge. Suicide prevention, despair, horrible problems. So you have to figure out how you behaviorally change people. So you build in the technology using behavioral sciences. So you blend the sciences, technology, and that's where the change is going to take place. So we developed what we call it a crim bit, tied to your heart rate. Makes a difference if they take it off. If there's a problem, we know right away. If you have a victim and you get close to the victim, it alerts. It's not just a piece of paper in our country with a domestic violence restraining order. It's something real time. It gives them all the things they need to do, the calendars for them if they need to go have their drug tested. It tells them what to do. It's interactive. And we designed it, and let's just say there was an administration change. You could think about that. And we, instead of investing in that tool that we were about ready to launch, they decided more ankle bracelets. More ankle bracelets that were designed for cows. More ankle bracelets, not using the technology and the behavioral sciences from the Harvard Law Brain and Behavior School to change behavior and to do better work. So I'm a very impatient person because I'm now old, and I want to be part of seeing change happen because it's been
You're one of the youngest people in the room.
I am not the youngest person.
Just my mindset. Just my mindset.
I'm not.
Curiosity.
I am.
You're almost childlike curiosity.
Absolutely.
I have a lot to learn. So maybe I am the youngest because I'm still back in those early days of learning. But I'm going to honestly tell you, this has been an overpowering experience. And to be in a room knowing the level of expertise and talent, I ask you to stand up and come at us, question authority, make us do better work. Don't let us get off the hook. I tell lawyers all the time in court, your job is to make me do better work. So push me to make those better decisions. Use the technology, and the bottom line, one of the reasons I think I ended up on the federal court, it has everything to do with children and families, and I'm not going to go there because that's not my topic, but I would love to, but anyway, I won't. But I'm going to tell you, I got there because the lawyers knew that, like everybody else, I had a family, and I would respect that their needs to do the work in a thoughtful way without destroying their life, because it's all about me. That we would work together, and I would use technology, and I would give them opportunities to do the work without hauling them into court every single time they had to do something. So for the last 3.5 years in Oregon, I've covered 3 parts of the state, 2.5 hours north, 3 hours south, Eugene. I traveled all the time. For the last 4 years, I haven't been in the courthouse. I've done everything remotely and on Zoom. Is it perfect? Nope. But you know what? It worked. It got people resources, and we moved the docket, and we moved things ahead. So I know it's possible. And I know the times when you have to be in the courtroom, and that is critical and important. But what we have to do is use our resources and sort better the cases that are out there so that we apply the resources in a strategic manner. So thank you for your time.
Thank you so much. So many calls to action there that we've all kind of internalized. I know one of them Mr. Shaw already has in place. He has a reverse mentoring program for himself, and several of his younger mentors are in the room. Judge McKenna, each of you do, but you especially have a lot of fans in the room. Some of them came to me in the break and said they want to hear from you about climate litigation and your sort of pioneering work there. Mm-hmm. But I personally want to hear from you about diversity, because I know you've spoken about it with a lot of passion. So technology has the ability to be more inclusive and to bring sort of more people into the fold, whether on account of gender, race, or faith. But by the same token, it holds risks in terms of amplifying biases that humans already have and compounding them. So I'd love to hear from you about your views on diversity and the opportunities and risks of technology.
Thank you. Thank you for that question. So before I directly answer your question, I just want to say wonderful ideas. Wonderful idea. I love that crim bit. So one thing that I really want to focus on, and Justice Adams and Justice Wilson have talked about this too, is that one thing we need to remember is that we have 2 different court systems in the United States. We have the federal court system, and then we have state court systems. And so in some ways, the state courts have always been and continue to be laboratories. We try different things that the federal courts do or don't do. And so it's possible that, a state court could do the crim bit and try it. And we can try different things in the state courts. Some work, some don't. In Hawaii, we have started online ADR, small claims for small cases, online ADR. We do remote here. Obviously, when COVID started, we went to Zoom hearings for all of our oral arguments. And so and a lot of our trial courts went to doing Zoom and remote hearings. And in terms of what Judge Staton said, we now have court rules being proposed to us as to which types of hearings and what kind of circumstances should we have continue to do Zoom hearings, and in what circumstances should they be live. But we found that now that I know that our traffic court cases are very minor cases, we will continue to do in Zoom. And Zoom has become a wonderful way, and I use Zoom, it could be any kind of remote platform. I'm just using it because it's such an easy way to say it, just like Xerox, right? It's just a brand name that becomes a technology. But in any event, Zoom hearings have really changed things, and COVID has really taught us a lot. It has become an opportunity also. But I do want to really focus on some issues. I was privileged to write a book chapter for a book that was edited by Professor Vice Chancellor Kumar on the legal profession and legal education before and after COVID. And I wrote about courts and COVID and how remote should the future be. And basically, there are a lot of studies, obviously, the use of Zoom, smartphones creates access to justice to so many people. Obviously, the issue becomes the digital divide. We have to make sure that everybody has internet access, everybody has smartphones, but it does open up a real world that people don't have to travel to get to court. People don't have to pay their attorneys to travel to get to court. They can appear by Zoom. But some of the studies have shown that there are issues. For example, when you don't have that human element, it affects the views of credibility. The studies clearly show that. And in fact, for example, Cook County in Illinois, they used to have a remote bail. How much would bail be? They found that the study showed that the bail amounts were much higher when it was done remotely. And Cook County abolished that remote system. When you don't have that person live in front of you and you're not looking at them to ascertain, the human element becomes important. Also, so in my view, Zoom doesn't work that well for credibility, but sometimes you do need to use it. You need to be aware that there are biases that creep in. Studies show that, especially cross-culturally, frankly, Black witnesses were viewed as less credible on Zoom. So, these are real issues that we all need to be aware of. If you're going to use it, you need to be aware of the problems and credibility determinations with Zoom. But I'm going to get back to what you talked about. The other thing is, technology has been wonderful. PACER, the United States federal court system, all of their filings are online. And now in the state of Hawaii, all of our court filings are online. So anybody can access any document, except, especially in state courts, and in federal courts too, we have to be concerned about the cybersecurity issues because we have a lot of confidential information, especially in family court matters. We have a lot of confidential information. So we have to make sure we do have processes and court rules dealing with sealing of certain information, providing publicly accessible information, and sealing and blacking out, the areas that should not be seen, right? Redacting those areas. So we do need to be conscious of cybersecurity, but so the balancing of the court filings, and that is really important. But I want to talk about judicial review. I'm going to go back to, I keep talking about state courts. Everybody talks about, and we studied Marbury versus Madison. I want to make it clear that judicial review, and United States started this wonderful experiment with the third branch. The British system was the legislature, the House, the court was in the legislature, right? But the United States created a separate branch, right? The US Constitution. Each state has its own constitution. Judicial review did not start in Marbury versus Madison. It started in the state high courts, the state Supreme Courts. Judicial review was well developed in the state high courts. Marbury versus Madison was just doing what the state courts were already doing. All right? Exclusionary rule, excluding evidence for violation of Fourth Amendment rights. That, Mapp versus Ohio. The United States Supreme Court was only doing what state courts were already doing, okay? So these constitutional concepts were actually developing in state courts, in state court constitutions. So I just want to impress upon that importance, because now it is the state courts that are now also leading on climate change, right? We are leading on climate change. So the rule of law requires, it's really important. This is a business meeting. My background, I grew up in Japan. I was in-house counsel, and it was really important that we be able to trust the judiciary for whatever country we invested in or whatever location we invested in. We needed to know that if we had a problem in our contract, that we could go to that judiciary, we could trust that judiciary to enforce the contract, and they wouldn't favor the local people, right? That is so important. So who is doing that reviewing? We talk a lot about the rule of law, but I want to leave you with a concept about the rule of law. The rule of law has 4 components. World Justice Project, please go online, World Justice Project. 4 principles of the rule of law. Accountability. Private and public actors are accountable under the law. Just laws. Laws have to be just. Open government. Government has to be open and transparent. Accessible and impartial decision makers. Accessible and impartial decision makers that reflect the communities they serve. So I posit to you that the rule of law requires that the judiciary be diverse. We in the United States are not in full compliance. I'm happy to say that the state of Hawaii has the most diverse judiciary in the country. We do represent our community, and we keep demographic information so we know what different ethnicities people are. We are 50% women in our judiciary. We have, I am the first Asian American of the LGBTQ community, open member to serve on a state court of last resort. We keep LGBTQ statistics of who is LGBTQ in the bar, in the judiciary and in the bar. Unfortunately, I submit to you that, but unfortunately, the United States, and we're not in full compliance because we, unfortunately, it's actually white men that are completely overrepresented, especially in the federal judiciary. But I submit to you that for public trust, rich deliberations, and to be in full compliance with the rule of law, judiciaries need to be diverse. And I am very concerned about the lack of women in your high courts and in your Supreme Court. So that is the thought that I want to leave with you with, and say that that is a requirement of the rule of law. Thank you.
Thank you. So profound. Really so profound. I think you spoke about the sort of elements of rule of law, and I think accountability and legitimacy of any public institution comes from looking like the people they serve, and therefore having diverse members. So I think really, really profound point. You also spoke of sort of state high courts, and we have a similar system in India where Article 226 of the Constitution is actually wider than Article 13. So I think several of us eminent jurists here probably had more power when they were in state high courts than in the Supreme Court, which is really interesting. I think they've sort of used that to good ends as well. Judge Tookey, I'm so sorry. Judge Tookey, it's very rare that men are in the minority, and you are on this panel. Actually, even in the firm, we have more women.
Thanks a lot for having me. I was laughing because I'm someone who doesn't even know what apps is. So I stepped behind these two. I don't know what. I have a flip phone, so if
more power to you for that.
You're in very good company.
There we go.
Very
so, but it's good because thinking about technologies made me think a lot about how can it be useful. And the reality is, I mean, I've been at the Court of Appeals for about 10 years now. It's changed everything. We had the good luck to sit with Chief Justice Lala the other night. He was kind enough to sit with us, and we talked about, opinions and drafting opinions in paper and everything. And I'm somebody now, the reality, I tried to get we have a sitting at the end of October, and I didn't get my homework done. I have about half my briefs read, but I have, we used to have paper briefs. Now they're on an iPad. So on the way home, I'll be reading briefs on the iPad. And so the point, I guess, we're with lawyers, to make to the lawyers is a lot of the technological advances in terms of how we do things are driven by lawyers. So I see myself as a public servant. I'm a judge that's doing my best for Oregonians. And so the lawyers, so in the briefs now, there's hyperlinks. You can click on the brief and that'll take you somewhere. But that was, again, suggested by the lawyers and put in the Oregon Rules of Appellate Procedure. So I would say to you all to be thinking about how technology can basically help the judges do a good job. And that's, I think, what's happening in Oregon. And so that's one thing. The other thing is just in terms of the broader question about commercial law and innovation. and technology. Padmaja mentioned it, and she's going to know this because she's at Citigroup and works in the U.S. in both state and federal courts. But I would say, you know, really as lawyers to be thinking of, so at the state appellate, we are getting big cases on climate change, on other resource issues. And you have to, a lot of times I'm surprised in the briefing that the lawyers don't, they know their case so well, and maybe the case is so in their head that I'm not a specialist in that area. And I think Judge Ellis mentioned this before, but really help the lawyers to see what you think. This is again at the appellate level, but what do you think the issues are, and help to best explain to them, you know, why you're right. And so, like I said, we get these big commercial cases. I wasn't a commercial lawyer, so sometimes I feel like I have to take a step back and even try to educate myself. So just, it's a lawyering tip since we're here, and a perspective about help the judges to do what you want them to do. So, right? I mean, it's to see things. So thank you.
Thank you. Thank you. Dean Nelson, you've had a storied career in legal education. I think the legal education system needs a complete reorientation to deal with the sort of tectonic shifts that we're going to see. What do you think needs to change for law students, but more seasoned lawyers and judges as well?
Thank you very much, and it's an honor and a privilege to be here. I want to commend you, the leaders of this firm, for doing so much, and I was particularly struck by the technology that you showed, where your colleagues in other firm locations are attending, and you can see them and they can see us, right? I don't know if everybody on the panel saw those images, and I'd like to suggest to you that this is exactly where legal education should be. I'd also like to suggest to you, and I hope you'll see why momentarily, that this is going to be an exacerbation of the haves and the have-nots within the next decade. So I plugged in while I was sitting over there this question into ChatGPT. The answers will not be surprising. They're very intuitive, but ask the resource question as I say this. So the question I fed into ChatGPT, you could use Bard, you could use whatever you'd like. I use ChatGPT. To facilitate the role of technology in promoting access to justice, law schools can take what steps? 1, these are the answers. Incorporate tech courses. Okay. Right. 2, legal tech clinics. Okay. Interdisciplinary collaborations. Makes sense. 4, research and development. Encourage the further research, the part of faculty and students to engage in this research. 5, interdisciplinary collaboration. 6, continuing education. That's what we're all doing here today. 7, public policy advocacy. Certainly that is crucial. 8, multidisciplinary approach. We've been talking about that over the last several days. 9, policy advocacy beyond the normal. 10, accessible resources. Okay, that's a good start, right? I think what we need to think about when we think about technology going forward is how we leverage that fundamental response that we've had to really amplify what we're getting churned out in these types of responses. But this is going to be a question, crucially, of resources. All of that in a constrained world takes resources. It takes hiring. Firing in the academia is not really an option in most cases, given tenure, but it takes hiring and hiring the right people. There are systems of tenure that will allow for some of this. There are systems of tenure that may not allow for it, but we're going to have to think about who to hire. Crucially, because of what Justice McKenna said, we're also going to have to think about the same things that technologists have to think about, is the diversity of that. Because you're programming bias in the same way that we program bias in the present world, right? If it's garbage in, it's garbage out, right? If we have discrimination presently, why would we think anything's going to change just because the modality is flipped to a digital platform, right? It's not going to change unless we change in terms of the coding and the programming, who's doing it, their lived experiences, their values, their virtues, their concerns, right? So when we talk about programming for bias, we're talking about the people who are doing the programming. And definitionally, we know that, generally speaking, those who are in charge of the technology are fairly homogenous. So we really need to talk about racial and gender diversity, especially as we think about the next generation of whatever, beyond Zoom, right? And we think about even the iteration of Zoom. From the 2010 Olympics, we saw the ways in which the holographic images could be used. I'd like to postulate that we should imagine the different ways in which, a la Star Trek, we will be able to see a 3D version of students in the same way that we'll see a 3D version in the present moment of plaintiffs, of those who are in the courtroom, etc. It's coming. The question is, are we ready for it? We'll have to think about our infrastructure, right? And I think this is where the public-private divide becomes even more pressing, because gone are the days when the budgets are seeing technology as fixed, as many of the budgets I've worked with. Technology is not a fixed or a capital project, right? It is an ongoing, everyday, to be accelerated, to be invested in part of our budgets, or else we are already obsolete. And I'd like to suggest to you, having lived in a number of different places, we are already obsolete in legal education, right? Having spent several years in the Netherlands, I mean, we didn't write a check talking about digital courage, right? The digital transformation, payment structures. But in the States, many jurisdictions, we still write checks. Do you write checks?
No.
Okay, right? Okay, so there is a massive catch-up that needs to be orchestrated in terms of so many of the systems and the infrastructure. Infrastructure, just like the roads, it takes investment. And I think what's going to have to happen in many law schools, especially if we're talking about publics and as opposed to privates, I think we're going to need to be serious about how we partner and collaborate with industry and private institutions that have the means that are often we don't have. And I also think it's important to think about what that's going to do going forward to education. Because generally speaking, right, for young people who can't afford some of the opportunities, they hearken to public schools. But public schools, generally speaking, are still in are going to be even more in a catch-up frame, just like public institutions, public projects. And so it behoves us to think more capaciously about the possibilities for public endeavors to allow for the possibilities. I'd also like to suggest to you that the legal education of today, when we are a little bit worried about what does online education look like, at the University of Hawai'i, we just launched a JD Online Flex program to increase access, to increase opportunity. I'd like to suggest to you that this is the wave of the future, because people want to be met where they are. And whether we like it or not, we have 3-year-olds, and if you give them a magazine, there's a viral image on YouTube, and you give a young person a magazine, they're going like this, trying to zoom the image, right? They are not flipping the pages. So they, fast forward in a decade or two, are going to come to us, and we're going to give them what, a casebook? Right? Even my kids who are 21, 23, and 25, educated in the Netherlands in terms of their high school, they didn't have a book. And then they come to American universities, right? And then Canadian universities, and we're still dealing in books. So it's a transformation. Even if we struggle with it in our generation, these are the generation of kids who flip right or flip left to date. Let's be real. So they have different ways of encountering and engaging the world, and actually the way they access credibility and love, right? This speaks their ability to access and assess credibility in a courtroom. Maybe it's not ours. But for those 15, 16, 17-year-olds who are living in this digital space, not alone Second Life, remember Second Life, which is now obsolete, their virtual world is far more robust than ours. So we are in a rapid race, and that race needs resources. It needs diversity. It needs some fearlessness so we don't lose ourselves in that race. But I would like to suggest to you that it's upon us. And we are rapidly trying to play catch up. So I very much look forward to, I agree with Justice McKenna, we need that feedback loop. And we need the feedback loop from you all, and we need the feedback loop from those who are 10, 6, 12, 14. What do they expect, right? In a space where they're already more digitally advanced than so many of us decision makers who are just struggling to catch up. I will leave you with this. When Nelson Mandela was in prison on Robben Island, he did his law degree at one of the London universities. And he did it by what was then radical, a correspondence class, right? That was a radical concept, being educated via the mail, via the post, as we would say in the Commonwealth, right? And we're still struggling with the next generation of correspondence classes, right? Surely we have to get over that, because that horse has left the barn. But look at what it did for Mandela, and we celebrate that, even though what he accessed then from a prison cell was seen as radical. These are no longer radical concepts. So we are in the bind, right? But the moment is upon us to try to figure out how we take that bind, that challenge, and leverage it into something that is possible to further justice and access for all.
Thank you. Thank you. Perfect note to end on. Thank you so much. This was really insightful. We teased out some really eternal questions about justice, as well as some more immediate ones about deploying technology. Can't thank you all enough for your generosity with sharing your views and opinions. Thank you.